Right, it is 3 o'clock and it's time for the hearing to begin to get underway. Our not being able to see the witnesses makes me ask whether all our witnesses are ready and standing by in virtual world. Good, thank you. I'm delighted to have the witnesses here. We're here on a very technical question of appellate process and appellate propriety that ordinarily would not merit the attention of the Senate. But because of what has transpired in some very important political decisions made by the United States Supreme Court, I think it's important that we take a look at this question. And the question is, what is the proper role in an appellate court for fact-finding? Now, when I was in law school and when I was being mentored as an appellate advocate, and later on when I did some mentoring as an appellate advocate, I learned basically that if you're an appellate advocate, you don't want to be raising factual questions in a court of appeal, because your odds are terrible. Appellate courts aren't supposed to do fact-finding. And the limited appellate role that they have over a trial court or a jury's fact-finding is subject to a very, very high standard, which is that the finding has to be clearly erroneous. There has to be no conceivable reading of the factual record that could support the factual conclusion that the court below drew. It's really, really clear that fact-finding is to be done at the trial court level, and it's not to be done at the appellate court level, with one minor exception, which is to take judicial notice of something. But you only take judicial notice of things that are indisputable, like that Christmas in this particular year fell on a Wednesday, or that Boston is north of Providence. That stuff doesn't have to be in the record because there's really no doubt about it. Courts are supposed to say what the law is, appellate courts anyway, and particularly the Supreme Court. The Supreme Court's job, according to Chief Justice Marshall, is to say what the law is. Not what the facts are, what the law is. And that brings us to the penchant of the Roberts Court's Republican majority for going off and finding facts, not ones that they could take judicial notice of, and not ones where they followed the ordinary appellate procedure of reviewing the factual determination of the court below, subjecting it to the clearly erroneous test, and if it found that it failed, sending it back to the trial court for further proceedings. And interestingly, this problem came up in two decisions in which the factual determinations made by the Republican majority in the Supreme Court were critical hinge points to the result of the decision. These weren't observations made in passing. They were factual determinations without which they could not have gotten to the conclusion that they wanted to get to. Shelby County was one of those cases, a challenge to the Voting Rights Act preclearance provisions. The Roberts majority in Shelby County made the finding of fact out of the clear blue sky that, quote, things have changed dramatically, and that minority voters no longer faced a threat of discriminatory laws out to restrict their access to the ballot box. Now, even if that fact were true, that Supreme Court had no business making it, if it found the record was insufficient on this or that it wanted to explore more what the facts were, they would have sent it back for a more robust record or clearer findings of fact. But they didn't. They just made this finding of fact. How'd it turn out? Turned out pretty darn badly. state legislatures in the states that were subject to those Voting Rights Act preclearance provisions went immediately to work to limit minority voting rights. Litigation exploded. Federal judges went to work making findings about what the states were doing, targeting minority voters with, as one court said, surgical precision. Preclearance jurisdictions saw poll closures, restrictive voter ID laws, voter roll purges. In fact, in the 24 hours immediately following the Supreme Court's ruling in Shelby County, Texas, announced a new strict voter ID law. Shortly after, Mississippi and Alabama began enforcing voter ID laws that would previously have been barred by preclearance. So clearly, the finding of fact that conditions in the preclearance states had changed to the point of view that preclearance was no longer necessary was not only highly questionable as a finding when the Supreme Court majority made it, it was irrebuttably disproven by later events. You simply can't quarrel with what later events showed to have been the case. And here's where it gets a little bit interesting, because this is such weird and peculiar behavior that there's no process for what you do in this circumstance. What do you do in a circumstance where the Supreme Court makes a false finding of fact? There's a separation of powers quotient to this restriction on what appellate courts can do, keeps them constrained, tethered to the actual facts before them in the case, less able to go wandering off on policy voyages of their own desires. But what happens? Where do you go when the Supreme Court hinges your decision on a fact that is false and is later proven to be false? What do you do with that? The Supreme Court has made no effort to clean up its factual error in Shelby County. Is it owed deference still by the other branches of government? Isn't Congress just as good at fact-finding? Isn't the executive branch just as good as fact-finding at the Supreme Court? Upon what merit or basis does a Supreme Court decision stand when the essential fact that allowed that decision to be issued in the first instance is false, and indisputably false? And it wasn't just Shelby County. On we go to Citizens United, another big political case giving a big political win for the Republican Party, in this case allowing unlimited political spending into our elections. Here there was a fact-finding trifecta by the Republican majority. First, massive corporate political spending in politics could not possibly be corrupting, because second, the unlimited spending would be independent of candidates and campaigns. And third, the unlimited spending would also be transparent. These factual determinations made by the court's majority stood on no facts. As Justice Stevens called out very plainly in his dissent, the record in this case, quote, is not simply incomplete or unsatisfactory, it is non-existent. And again, all of these facts that the Supreme Court found, upon which the Citizens United decision hinged, are provably wrong. Corruption can exist because of unlimited spending, and indeed it has emerged. Just look at the end of climate legislation. Independence between the big donors and campaigns is a mockery, as numerous articles and reviews and analyses have pointed out. And all you have to do is turn on the TV to see a fake ad by a phony front group to know that transparency is non-existent. And once again, the same problem. The court spent a decade watching its factual findings be disproven and never stepped in, despite repeated opportunities to clean up the mess that it had made from its error. So now we have two very important decisions that played an enormous role in the political outcomes of this country that were both very important to the Republican Party to win. In both cases, a Republican majority on the court invented or created or imagined facts that got them where they needed to go, that helped the Republican Party win those cases. And then they never stood back and cleaned up once their facts were proven demonstrably wrong. So, unfortunately, these two particular decisions figure into a much larger pattern of over 80 decisions in which the Roberts Court Republican majority writes 5-4 decisions with all the Republicans lining up that provide political reward to powerful Republican interests. A lot of those 5-4 partisan decisions break rules of appellate practice and principle. A lot of them break what are supposedly the rules of conservative legal practice. But in these two cases, it was the rule against appellate fact-finding that was sacrificed. Imagine that the court was facing pandemic restrictions, and it reviewed the pandemic restrictions put in place by governors and mayors by finding that the virus at the heart of the pandemic could be cured by ingesting disinfectant or bleach. And imagine that that were not true. You'd have undercut government's ability to deal with the pandemic. You'd have done so on a completely false and manufactured factual assertion. And where do you go for that? If it's the Supreme Court, there's no further court of appeal. And if the Supreme Court wants to sit on that fact and never correct it, there's no vehicle to force its hand. So does that then open a role for the other two branches of government, for the legislative branch or for the executive branch, to step in and say, those decisions are founded on a demonstrably false predicate. And when the predicate fell, so did the decision, and therefore these decisions of the court are not entitled to the customary deference that we give court reviews. To consider this, we have some very knowledgeable and interesting witnesses who are before us today, and I'm very grateful that they are here. I will find in a moment my list of them. Here they are. I think we'll go in the following order, just so that everybody will know. We'll start with Allison Orr Larson, a professor of law at William & Mary Law School, who teaches constitutional law. She has worked before on this issue and has been published in the media on this issue. She's a fellow law graduate, though far more distinguished, from the University of Virginia, and a clerk for Judge Wilkinson from the U.S. Court of Appeals for the Fourth Circuit and for Justice Souter on the Supreme Court. After her, I will recognize Thomas Fisher, who's the Solicitor General of Indiana since 2005, who handles the appellate work for the state of Indiana. He's also a fellow of the American Academy of Appellate Lawyers, an adjunct professor of law at Indiana University Moore School of Law, and a former clerk for Judge Michael Kahn of the Seventh Circuit Court of Appeals. After him, we will hear from Theodore M. Shaw, the Julius L. Chambers Distinguished Professor of Law and the Director of the Center for Civil Rights at the University of North Carolina School of Law at Chapel Hill. He teaches civil procedure and advanced constitutional law with particular focus on the 14th Amendment. He's previously served as the Director, Counsel, and President of the NAACP Legal Defense and Educational Fund and has considerable experience with the facts that surround the Shelby County decision. He began his career as a trial attorney in the DOJ Civil Rights Honors Program, and as a former DOJ employee, I'm always delighted to see that. Next will be Ilya Shapiro, Vice President of the Cato Institute, Director of its Robert Levy Center for Constitutional Studies, and publisher of the Cato Supreme Court Review. He has recently written Supreme Disorder, Judicial Nominations in the Politics of America's Highest Court, and has filed more than 400 Supreme Court amicus briefs, and as well has been an adjunct law professor at George Washington University and the University of Mississippi. And we will close out with Paul Smith, the Vice President for Litigation and Strategy at the Campaign Legal Center. He is also a professor at the Georgetown University Law Center, where he teaches election law and constitutional law. For 35 years, he has focused on appellate and Supreme Court practice and has argued 21 cases in the U.S. Supreme Court, which is 20 more than I have. And I'm delighted to have this panel of witnesses. I should add that Paul was also a law clerk for Supreme Court Justice Lewis Powell. So if I may, let me ask Ms. Professor Larson to lead off with her testimony. Ms. Larson, the floor is yours and the camera is alive.